see these player evaluations that you asked me to do.
I asked you to do 3.
Yeah,
To evaluate 3 players.
yeah,
How many did you do?
47.
Okay.
Actually, 51. I don't know why I lied just then.
Like you, be strong to hold the powers of the sun.
I show you how deep the rabbit hole goes.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. Now, in this episode, I really wanted to have this one out to you first, but as I started putting it together, I realized this one was going to take a lot of work. So I've been working on it intermittently, but I finally have it finished, so I wanted to get it out to you before I break down any more of these motions. And this is the outcomes of everything that was discussed in that hearing, because the judge gave rulings on some things, other things he reserved for his written order. So we're going to go through each and every one of them one by one so we can clearly understand where we are at with the outcome of that hearing. And by doing it this way, it's kind of eye-opening. The defense did pretty good. Let's get right into it. Okay, so again, here is our list of all of the motions, and we're going to go through here, and I'm going to show you one by one what the actual decision was, if there was a decision, and give you an update on exactly where we're at on everything, including the extra 2 that I didn't have on that list that we'll be talking about. One I did a video on the other day, which was motion to exclude the death penalty due to disclosure violations. And what's weird is they filed a motion for leave for the death penalty motions so they could even file those 2. I never seen a ruling from the judge, but he must have ruled that they could file the motions or else he wouldn't have heard the testimony in court. So I'm assuming that was a yes to that ruling. But we're going to go through these things one by one. And let's get started with the first one.
I am ordering that the state and its witnesses not use those 2 terms where they're equivalents. With respect to the term murder, outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it, because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury.
All right, so the first 2 motions were by the defense, and they were motions to exclude the use of terms psychopath and sociopath, as well as describing the defendant, Mr. Kohberger, as a red rummer. And the judge ruled in favor of the defense on both of those motions, so they won the first 2. Next is the 404B evidence that I did a video on, and we broke it down, but the ruling on that, I don't know if I broke that down. Let's go ahead and get that ruling.
That the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant, and it does potentially create some unfair some danger of unfair or unnecessary prejudice. So I think it needs to be redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
So on the 404B evidence, the judge is, even though he said he's going to do some redactions to the video, he is going to allow the 404B evidence and the video as an exhibit in the trial. So next, we've got Kohberger's family members being in the courtroom, and see what the outcome of that one is.
And so I do see some issues where family members may be important. And so I think there may be some need for exclusion, but I think the best way to handle that is to get them on and off as quickly as possible at the beginning to deal with that. I'm reserving ruling on that. I want to look at it, and I will issue a written order on that in due course.
Okay, so the judge did not issue a ruling on whether or not Bryan Kohberger's family members can be in the courtroom. So we're going to have to wait on his written order. And anytime he says he's going to do a written order, or do you hear him say, "I'll take it under advisement"? When he says, "I'll take it under advisement," that means he's not going to issue an order right now. He's going to submit a written order. So some of these things that we're looking at, he did not rule on, and we'll point those out as we go, this being one of them. Next, we have what they call the conditions as aggravator as it relates to the autism spectrum disorder. And this was more of an argument for mitigation, but it was still an argument, so we're going to listen to how he rules on it.
Aggravating factor in the penalty phase. The state certainly shouldn't make those arguments, and are instructed not to do so. In terms of the actual evidence, the presentation of evidence, I think I can certainly say don't make that argument that the fact of the diagnosis is somehow an aggravating factor. And we can deal with the symptomology that the defense contends is part of the diagnosis, that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor.
Okay, so the judge ruled in the defense's favor that the prosecution cannot use the conditions of autism as an aggravating factor when it comes to the mitigation. Next, we have a huge motion, and I will be doing a complete video on this one. And this is the prosecution's motion in limine to exclude alternative perpetrator evidence from the defense. And remember, they wanted the defense not to be able to present alternative perpetrator evidence. And how the judge rules on this one is very interesting. And let's go ahead and hear that ruling, and then I'll do a video breaking this one down for you. This one was big.
I think the parties are both correct in that State v. Meister is controlling here, where the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person rather than just throwing names out or arguments or theories out without evidence to support that. I don't want to do that at trial. I think that's not enough time for the state then to investigate that. And I don't think it's enough time for the court to respond to that. And I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers and go from there. Now, things may, I'm not discounting the fact that things may unexpectedly happen after that, but in terms of what we are or should be aware of at this point, I think we need to flesh that out before we go down that road. And so I will probably reach out with your calendars and set a date sometime around that pretrial, maybe even during that pretrial since you're here to take care of that.
Okay, now that one was a huge win for the defense because the judge could have said, since there's no evidence that has been proffered at this time for alternate perpetrators, then motion granted, you cannot present that evidence, but he didn't. He said that he wanted the proffer, which means the evidence for the alternate perpetrator, admitted sometime before trial, and he would get with the parties and issue a deadline for that. So that was a huge win, and I will go into a lot of detail about that one. But next we have the defense's motion in limine as regards to the statistical analysis of Q1.1, which is the DNA on the knife sheath. Now, this one's kind of interesting because they don't really say what was said in the grand jury, but apparently what was said in the grand jury contradicts that 5.37 octillion. So it is interesting. However, let's see how the judge rules on it.
As to how you question with respect to statistical analysis, I guess as guidance, it seems to me the answer that was given to a question that the analyst kind of rejected is probably the way the state ought to approach it, but I'm not going to tell them exactly how they have to ask the question. What I will say is I will make sure I'm aware of the way that it was asked in a way that was concerning, and certainly if a question is asked in a way that is concerning, the defense can object, and I can respond accordingly.
Okay, so that one is actually a loss for the defense because they wanted to exclude the prosecution from being able to ask certain questions as it relates to that statistical analysis, but the judge wouldn't rule to exclude it. He simply gave the prosecution a kind of a talking to and said, if y'all bring it up at trial, then the defense can object to it. Well, if they're going to bring it up at trial, the defense will object. The judge can sustain the objection, but still the jury will get to hear it. So it'll still have the impact that the defense didn't want it to have. So it was a loss on that one. Now, the next one is the testimony of Riley Nolan. And this one had two parts to it. The first part was her giving her opinion on whether the DNA on the knife sheath could have been left there due to direct contact. Right? The defense wanted that to be excluded because no expert could determine if it was put on there by direct contact. But then the second part was to eliminate the use of the term touch DNA altogether. So this is a two-part motion, so we're going to listen to it in two separate parts and get the ruling from the judge.
Right. I'm going to take under advisement the issue of Ms. Nolan's testimony about her conclusion of the likelihood of direct contact of the DNA.
All right, remember, no or under advisement means no decision. He's going to look at it and then issue a written order on that one. So that one we'll be waiting on. Next is the touch DNA, being able to exclude people from actually saying touch DNA during the trial. Let's see the ruling.
As to the use of the term touch DNA, I'm not going to preclude it. As I indicated, I think it's a discretionary matter. Their science in that area uses the term to have a particular meaning. That meaning can be explained to the jury through the experts. In addition, much as the term victim, there's an instruction for, I'm not opposed to giving an instruction to the jury should that term come out, that the court is not intending to, by use of that term or by any of the attorneys' use of that term, making a conclusion.
All right, so once again, even though the judge gave some additional instructions around it, he said, I'm not going to preclude use of the term touch DNA. So that is ruling in favor of the prosecution and against the defense on that one. Next, we have the defense's motion in limine regarding the use of calling suspect vehicle the same vehicle throughout the videos. And specifically, the defense was asking that the prosecution, during arguments, opening statements, and during the actual questioning of witnesses, not refer to the vehicle as the same vehicle throughout the videos, and to let the FBI agent's testimony be the ultimate determination of fact. And let's see how the judge rules.
My inclination is certainly the state should not be making conclusions outside of closing statement. I don't think calling the vehicle suspect vehicle one is making a specific conclusion. It's, again, using a term that is used within the investigation, but specifically making an argument that the various vehicles, or the various images of vehicles on the various surveillance cameras is the same vehicle, making that conclusion is an argument. And so that wouldn't be appropriate. I think in opening, for example, you can say that the testimony will be, right? As to the agent's ability to make that conclusion, I don't believe that that is an ultimate opinion of that is taking the ultimate conclusion from the jury. I think that's right within the province of expertise, and I don't believe, based on the evidence, that it is speculative, such that the agent shouldn't be allowed to offer that testimony. But I will write up further my analysis on that.
All right, so that was a ruling against the defense, although the judge did leave a caveat that he would write up some additional language around it. But yeah, that one didn't go their way. Now, the next one, though, is a huge one, as we all know, and I will be doing a video on this. You know I will. And this was on the defense's motion to exclude eyewitness testimony as it relates to the use of the terms bushy eyebrows by DM. Let's hear what the judge has to say on this one.
And there is not certainty with DM in what she saw. And the court now has, over a variety of motions, all of the transcripts that you can look at to understand the amount of uncertainty that she expressed.
Thank you. I'll take that issue under advisement.
All right, so he did not rule on whether or not to exclude the bushy eyebrows. We got to wait for the written ruling. Next, we have the prosecution wanted to include the 911 call. And let's hear what the determination is from the judge on that one.
Well, there are several things that I have to look at. One is, first of all, is it hearsay? Is it an assertion, right? So is it offered for the truth of the matter asserted? We get to those two things. Then we look at, is there an exception? For each of those two things, it generally means it's an out-of-court statement, then it's, unless otherwise definitionally excluded, hearsay. Unless there's an exception, then the exception being the excited utterance, and then we look at the surrounding events. Is it common or current present sense impression? Look at the surrounding events, what's said. Much of it is not assertions necessarily, or I would imagine some of it not offered for the truth, but simply to establish a timeline. And so I'll look at all of those things, but I don't think I can just look at the whole thing in whole and say, well, because they later on were doing things that 19, 20-year-olds do with their phone, doesn't mean that what happened earlier wasn't an excited utterance.
I understand. Our position is that those things that happen immediately thereafter impact the nature of those text messages that occurred between the two.
All right, so there's another one we've got to wait on the written ruling for, although he did allude to ruling in favor of the prosecution on that one, but we got to wait and see. Next is the use of the Barbie dollhouse as an exhibit. The defense doesn't want that in, but the prosecution filed a motion to include it as a demonstrative exhibit. Let's hear the judge's ruling.
I will give you a written decision on this soon, shortly, but there is a significant distinction between demonstrative trial exhibits or trial models, charts, things of that nature, and attempts to use things for evidentiary value in and of themselves.
So we didn't get an answer on the Barbie dollhouse being included or not, so we're going to have to wait for the written ruling on that. Next is a very interesting one, and it's interesting because it's the self-authentication of records that the prosecution wants to include into evidence. And just so happens that well past the deadline now, I mean, they're in the middle of having the motions in limine hearing, the prosecution hasn't provided the certifications for the self-authenticating records. And the judge just kind of brushes it over and says, well, since you haven't done that, we can't deal with it at this time. And just kind of pushes it off, which is some extreme BS.
All right, next I have self-authentication of records and reliance on 803. I'm not sure we're ready to argue this because I don't think the state has complied with the obligations in order to rely on the self-authentication issue if they haven't provided the specific documents and certificates that they're intending to rely upon in advance of the motion at this point. So I'm not sure that this isn't premature.
Yeah, Your Honor, we agree. That's probably an accurate statement, and a better time will be after the exhibit witness list is due, and then the parties have to get together and determine what exhibits we have objections to, and then we can address this issue.
Part of my scheduling order is a meet and confer over the exhibit lists to determine whether there's a good faith basis for an authenticity objection or not. And certainly the rules on self-authentication are crystal clear as to what is allowed. And so if it meets those, then I imagine we won't have a problem.
Okay, so the state wasn't ready with their records on that motion, and of course the judge doesn't admonish them. He just says, okay, makes an excuse for them and puts it off. So we got to wait to hear on that one, which is typical. However, the next one is a critical motion, and this was by the prosecution to exclude the defense's alibi. And I will do a whole video on this one, but let's just get the ruling first.
Well, why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness.
Yes, sir.
Where the alibi instruction likely is not going to be given.
Yes, sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Now, contrary to what you heard Thompson say at the end there, that's exactly what we were looking for, Judge. BS, that was the opposite of what he was looking for. They have tried to exclude the alibi and anybody testifying on behalf of the defense for an alibi for 2.5 years. And the judge did not rule to exclude the alibi. In fact, he left the door open if the defense came up with another witness that could establish his alibi. He left the door open for the defense to be able to bring it in. So that one was enormous. The defense has the ability to present an alibi. They have the ability for Ray to partially corroborate it and cross-examine state's expert witnesses on it, and if possible, produce an alibi witness. The complete opposite of what Thompson had been asking for, regardless of what he just said. So absolute win for the defense. Overruled that motion in limine. Now, the next one is the one I did a video on the other day, and that was the self-authenticating records. And let's listen to the ruling on it.
Now, if you want to voir dire him before he testifies in front of the jury, I'll allow that. And if you show a factual basis for it, I'll allow it. But you haven't at this point.
I appreciate the opportunity to ask the question outside the presence of the jury. Thank you.
Thank you.
So that was the one we went over the other day, and that was a big win for the defense. They get to ask the question to the FBI agent about time and advance records on voir dire on the stand out of the presence of the jury. So big win. The next one is the defense's motion to exclude vague and undisclosed expert testimony because the prosecution provided vague and undisclosed expert testimony. See how the judge rules on this one.
The state did not comply with Rule 16 or with the court's order, and the court should limit what they're allowed to produce at trial.
All right, I'll take that matter under advisement. I did invite the parties to supplement. It takes time to supplement. I'll look through to see if there's any significant new additions. Well, first, I'll look to see if what is given is adequate, if there are concerns. Secondly, if there's anything that was provided that wasn't shaping and as I've said, making more fulsome, making more whole, making more clear what opinions there are. The defense I know was given, and as I explained, the defense has the ability to supplement as well in response to the state's supplementation. Part of the reason the discovery order is as early as it is to the trial date in this case is because, in my experience in cases of this, we have this problem always of ongoing, continual supplementation and disclosure, and so I wanted to accommodate that within the time frame, within the several weeks to months in advance of trial. And so I'll look at it and I'll get you an opinion.
So we got to wait for the judge's ruling on that one. And the next one is the defense's motion to exclude the Amazon click activity. Let's see what the judge has to say about that one.
So I think there's a fundamental, just different worldview as to the relevance and impact of the Amazon data. And the defense is entitled to challenge the data in terms of, does it really show who bought it? What else did they buy? In what circumstances? I understand the state's not really going down that apart from what the data shows, which is the purchases that have been laid out in the report. If the state tries to go beyond that without having disclosed those, or without a rebuttal disclosure to some of the things the defense has disclosed on that, then they're not going to be allowed to testify to it. But there's not a ground for exclusion because you have an expert that thinks that the evidence can be explained in a different way. That's just simply a fact determination for the jury based upon the conflicting evidence.
So he ruled against the defense's motion to exclude the Amazon click activity, although I don't think that's a shock to anybody. The next one, though, is the prosecution's motion to exclude the neurological evidence.
I'll take the matter under advisement. The counsel cited cases that weren't cited in the briefing, so I'll need to look at those.
There's another one we got to wait for the written ruling on. Now we have the defense's motion to preclude the death penalty due to autism spectrum disorder.
Abilities like ASD cannot properly be reliably mitigated in front of a capital qualified jury. And that's why you should strike the death penalty in this case. Thank you.
Thank you. I'll take the matter under advisement and issue a written opinion.
So again, we got to wait for a written decision on that. The next one is the defense's motion to exclude the prosecution from claiming that the DNA under Maddie's fingernails was inconclusive to Bryan Kohberger's DNA.
Presents a false premise to the witness. And so we just ask that the state refrain from that and simply ask the questions that elicit, the testimony as laid out in the grand jury proceedings.
Okay.
Since he just said okay, I don't think we can come to a real conclusion on that one, so we can assume we're waiting on that ruling. And then the last one is the defense's motion to exclude the death penalty or preclude the death penalty due to many disclosure violations by the state. And I did a long video on this one for you the other day. I don't know if we ever got to the end decision on it, so here it is.
I will look at the issue and issue a written opinion on the matter because I think
So we're waiting on the written order for that one as well. But when you take a look at everything collectively, even minus the things we're waiting on the written orders for, the scorecard looks pretty good for the defense, in my opinion, based on the different motions that they won. Check it out. Okay, so here is our chart, and you can see, just a reminder, all the ones in pink were the motions in limine by the state. And then when we come all the way across, you'll see if they're in green, I've got ruled in favor of the defense. This one right here, this IGG one, you have to really default to the defense because they both had one and they didn't have a ruling on it. But all these ones in yellow are ones we're still waiting on. And of all of the prosecution's motions, the judge only ruled in favor of one of them, and that was improper death penalty statements. And one of them they weren't prepared for. He ruled in favor of two of them for the defense, and the rest of them were waiting on orders. So that's a pretty big difference right there. And then when you go to all of the defense motions, you can see it's a lot more spread out, waiting on a decision. The judge ruled in favor of the prosecution on 4 of them, ruled in favor of the defense on 4 of them. One of them he took under advisement, which means he's going to rule, and he ruled for the prosecution. So that's a still waiting on part of that one. And then a couple of them we don't have decisions on. And then down here, we don't have decisions on the motions to preclude the death penalty either. But when you look at the motions that he ruled in favor on, such as, well, let's see. The ones that were really important to the defense was these first 2. Alternate suspect evidence and the alibi. And the AT&T timing advance reports. He ruled all of those in favor of the defense. And if you went through and just added up the scorecard, you've got 1, 2, 3, 4, 5, 6, 7 of his rulings were in favor of the defense. Only 5 was in favor of the prosecution. Well, 6, because there was 2 parts to this. So interesting. More of the motions were ruled in favor of the defense than they were of the prosecution, and the biggest ones so far have been ruled in favor of the defense. Now that is really interesting, I thought, and I've been working on this video for you since the hearing, because I knew after watching that hearing, because of how ridiculous the judge was actually treating the defense team in that hearing, it made emotions go way up, and it seemed like it was doom and gloom the entire hearing for the defense. But when you actually slow it down and you just look at how the judge ruled on the motions, regardless of how he was talking over the defense and treating them, that didn't play into how he ruled at the end of the motions. So that hearing actually, so far, it's come out in the defense's favor, I mean, by far. And we still have a lot of those things that he hasn't ruled on. So we'll wait for the rulings on those, but I wanted to get this video out to you, even though this was probably the most difficult video that I've ever done. It took me forever to put all this together, but I wanted everybody to have a clear understanding of what really took place in that hearing and where we sit as of today. So I will be getting some more videos to you on that hearing, because there's a couple of them. Well, there's 3 I know of off the top of my head that I've got to put together that are huge. And then once I get done with that, I've got a major video with some major information that True Crime Design has come up with more information on my Aryan family crew that lines up so perfect. I couldn't make this stuff up. But in the meantime, please like and subscribe to the channel. Post your comments, thoughts, criticisms, and until next time, Pavarotti is out.